Question 1. In a high-stakes environment where multiple challenges arise simultaneously in representing a corporate client, an attorney learns that the client is involved in unethical practices that could lead to legal consequences for both the company and its executives. The attorney faces a conflict between continuing representation and fulfilling ethical duties. What should the attorney do next? A. Continue representing the client but advise the executives to seek independent legal counsel. B. Withdraw from the representation if continuing would result in violating the attorney's duty of candor or implicate personal interests that conflict with the client's interests. C. Continue the representation, keeping the client's secrets and refraining from disclosing any information even if it could protect third parties from harm. D. Seek from the client to continue representation despite the conflict while withholding details of the unethical behavior. Answer. B. Withdraw from the representation if continuing would result in violating the attorney's duty of candor or implicate personal interests that conflict with the client's interests. Explanation. An attorney is bound by ethical duties such as candor to the tribunal, Model Rule 3.3, and the duty to avoid conflicts of interest, Model Rule 1.7. When an attorney learns of clients' unethical behavior that could lead to legal consequences, they must evaluate whether continuing the representation compromises their duty to the legal system, the public, or their personal interests. Model Rule 1.16 requires the lawyer to withdraw from representation if their continued involvement violates ethical rules, including when conflict of interest arises. Moreover, in corporate setting, attorneys must navigate corporate responsibility, ensuring that their actions indirectly support unethical corporate conduct. Therefore, the correct response is to withdraw if the continued representation poses ethical concerns or risks violating professional rules. Question 2. While investigating a complicated issue between different departments in a law firm, an attorney discovers that one of the departments has been improperly handling client funds, violating fiduciary duties and ethical rules related to trust accounts. The attorney has a duty to report this issue internally. What are the attorney's obligations under professional conduct rules? A. The attorney should only report the issue if it involves significant financial harm to clients or if the client explicitly requests it. B. The attorney should immediately report the issue to the relevant disciplinary authorities and seek external intervention. C. The attorney should report the issue to senior management or the firm's compliance officer as long as the issue is addressed internally. D. The attorney is not required to report the issue unless it public knowledge or the firm receives complaint from clients. Answer. C. The attorney should report the issue to senior management or the firm's compliance officer as long as the issue is addressed internally. Explanation. According to Model Rule 1.13, attorneys have duty to report violations of law or ethical rules within the organization. When such violations concern client funds or trust accounts, the attorney must first raise the issue internally, typically through senior management or compliance officer, allowing the opportunity to address the problem. If the firm fails to act, the attorney may need to take further steps, which could include reporting to disciplinary authorities. While attorneys are encouraged to resolve issues internally, they also have the ethical duty to protect client interests and uphold professional standards. Immediate reporting to external authorities may be required if internal mechanisms fail to adequately address the issue, especially if clients being harmed. Question 3. During an emergency response where multiple areas are impacted, a lawyer representing a government agency learns confidential information about an ongoing investigation. The lawyer realizes that sharing this information with other governmental bodies could lead to a faster resolution of the emergency. What ethical considerations should the lawyer evaluate before disclosing the information? A. The lawyer can disclose the confidential information to other governmental bodies because it could help resolve the emergency more quickly. B. The lawyer should refrain from disclosing any information, as doing so could violate the attorney-client privilege and harm the client's case. C. The lawyer should first evaluate whether the disclosure could be justified under exceptions to confidentiality, such as to prevent harm or criminal activity. D. The lawyer should only disclose the information if they have obtained the client's consent, as there are no exceptions to confidentiality. Answer. C. The lawyer should first evaluate whether the disclosure could be justified under exceptions to confidentiality, such as to prevent harm or criminal activity. Explanation. The duty of confidentiality, Model Rule 1.6, prohibits lawyers from disclosing information relating to the representation of a client unless the client consents or there are recognized exceptions in situations where confidentiality must be maintained. An attorney may, however, disclose information if it is necessary to prevent harm or further criminal activity as allowed under Rule 1.6b1. In emergency situations, if disclosure is critical to prevent harm, e.g., to prevent a disaster or ongoing criminal activity, the lawyer can disclose confidential information without the client's consent, provided the disclosure is proportionate and necessary to achieve the purpose. Information solely for efficiency without valid exception could violate the ethical duties owed to the client. The attorney must carefully weigh whether the disclosure is essential to resolving the situation, ensuring they only disclose as much as is necessary. Question 4. While analyzing the root causes of sequential problems in a major litigation case, an attorney realizes that the law firm has failed to update its internal policies regarding client confidentiality, leading to inadvertent breaches of confidentiality in several cases. The attorney recognizes the need for corrective action, but there are concerns that reporting these violations internally could affect the firm's reputation. What should they do to fulfill their ethical obligations? A. The attorney should report the violations internally and work with the firm to establish corrective measures without informing external authorities unless the violations escalate. B. The attorney should ignore the issue, as reporting internal breaches could harm the firm's reputation and affect the firm's clients. C. The attorney should resign from the case and inform the affected clients about the breaches, seeking guidance from external legal authorities. D. The should inform the appropriate disciplinary authorities immediately, without reporting the issue internally to the firm. Answer 8. The attorney should report the violations internally and work with the firm to establish corrective measures without informing external authorities unless the violations escalate. Explanation. Under Model Rule 1.13, a lawyer representing an organization must report any breaches or unethical practices within the firm to the appropriate internal authority, such as senior management, if the firm is failing to adhere to legal or ethical standards. The attorney's duty is to take steps to ensure that the firm corrects the issue internally. If the issue persists and affects the client's interests, external reporting may become necessary. However, the lawyer is not required to report to disciplinary authorities immediately unless internal remedies are ineffective, as per Model Rule 1.13b. The goal should be to address the matter internally first, aiming for corrective measures that ensure compliance with ethical standards and confidentiality requirements. Question 5. When developing a solution that must address the posing needs within a complex merger agreement, an attorney is faced with a situation where they represent two parties whose interests are directly at odds. How should the attorney handle the potential conflict of interest, especially in light of the firm's policy on dual representation? A. The attorney may continue representing both parties as long as the attorney obtains written consent from both clients after fully explaining the conflict. B. The attorney must withdraw from representation of one party if the conflict is substantial and cannot be resolved through consent. C. The attorney can continue representing both parties without obtaining consent, as long as the merger agreement is beneficial for both parties. D. The attorney escalate the issue to a higher authority in the firm, but maintain the dual representation until further instructions are given. Answer. B. The attorney must withdraw from representation of one party if the conflict is substantial and cannot be resolved through consent. Explanation. Model Rule 1.7 prohibits lawyers from representing multiple clients in matters where there is a conflict of interest that could materially affect the lawyer's ability to represent each client effectively. In this scenario, the attorney must assess whether the conflict is substantial, and if so, then either resolve the conflict by obtaining informed consent from both clients or withdraw from representing one of the parties. The dual representation of clients with opposing interests typically violates the ethical duty of loyalty, especially when the conflict cannot be effectively mitigated by consent. Model Rule 1.7b. The attorney must prioritize both clients' interests and avoid situations that would lead to divided loyalties. Question 6. In a situation where resource allocation becomes increasingly complex across multiple offices of a multinational law firm, a senior attorney discovers that one of the firm's junior lawyers has been overbilling clients, including falsifying time entries for work not actually performed. How should the senior attorney handle the situation to ensure compliance with professional ethics and legal billing practices? A. The senior attorney should report the junior attorney to the firm's internal ethics committee and seek to recover any improperly billed amounts. B. The senior attorney should confront the junior lawyer privately, instructing them to correct their billing practices, but keep the issue internal to the firm. C. The senior attorney should immediately terminate the junior lawyer's employment, report the issue to the disciplinary authorities, and refund the clients. D. The senior attorney should ignore the overbilling unless client complains directly about the charges. Answer A. The senior attorney should report the junior attorney to the firm's internal ethics committee and seek to recover any improperly billed amounts. Explanation. Model Rule 1.5 and the ABAS guidelines on legal fees require lawyers to bill clients in a manner that is fair, accurate, and transparent. Overbilling and falsifying time entries is serious ethical violation that undermines the client's trust and violates the duty of fairness to clients. The senior attorney is obligated to address the issue both internally by reporting the misconduct to the firm's ethics committee or management, and externally if necessary, such as reimbursing clients or reporting the violation to appropriate authorities. Lawyer cannot ignore billing issues as they undermine integrity of the legal profession. Prompt corrective action is necessary to ensure compliance with ethical standards and prevent further harm to clients. Question 7. During an emergency response where multiple areas are impacted by a national crisis, an attorney learns confidential information regarding an investigation involving government officials. The attorney is tasked with handling this matter, but disclosing any information could violate attorney-client privilege. What should the attorney do to balance the ethical duty of confidentiality and the potential need for disclosure to prevent harm? A. The attorney should immediately disclose the information to relevant authorities to assist in the crisis despite the confidentiality obligations. B. The attorney should withhold the information completely, as attorney-client privilege cannot be waived under any circumstances. C. The attorney should evaluate whether the disclosure is necessary to prevent imminent harm or criminal activity and seek the client's consent if possible. D. The attorney should disclose information to the relevant authorities without seeking the client's consent, arguing that the public interest outweighs confidentiality. Answer. C. The attorney should evaluate whether the disclosure is necessary to prevent imminent harm or criminal activity and seek the client's consent if possible. Explanation. Under Model Rule 1.6b, an attorney may disclose client information if it is necessary to prevent substantial harm, criminal activity, or to comply with other legal obligations. However, disclosure must be proportionate to the harm that is being avoided. Situations where there is significant risk of harm or illegal activity, the attorney is permitted to disclose confidential information without the client's consent. However, the attorney should first try to obtain the client's consent if possible. In cases involving national emergencies or potential threats, balancing confidentiality with public safety and ethical duties requires careful consideration, and the lawyer must act in a manner that minimizes harm whilst fulfilling their professional responsibilities. Question 8. In a multi-location scenario where consistency requirements are paramount, a partner in a law firm is aware of a senior associate engaging in conduct that could potentially harm the firm's reputation, such as making misleading statements to clients about the scope of legal services. How should the partner handle this issue to maintain the firm's ethical integrity? A. The partner should ignore the behavior as it does not directly violate any ethical rules or laws. B. The partner should immediately intervene, advising the associate to stop making misleading statements and report the issue to firm leadership. C. The partner should allow the associate to handle the situation independently and avoid further involvement. D. The partner should suspend the associate temporarily until the matter is investigated thoroughly. Answer. B. The partner should immediately intervene, advising the associate to stop making misleading statements and report the issue to firm leadership. Explanation. The ethical principle of candor to clients, Model Rule 4.1, mandates that attorneys must not make false statements to clients, including misleading statements regarding the scope of legal services provided. A partner in the firm has an ethical obligation to supervise the work of associates and ensure that client communications are truthful and accurate. When aware of a potential ethical violation, the partner must take action to prevent harm, advise the associate to cease the misleading conduct, and inform firm leadership of the issue. Failure to act could result in disciplinary action against both the associate and the partner, as well as damage to the firm's reputation. Question 9. When implementing new protocols in a shared environment between attorneys and non-lawyer assistants, the supervising attorney becomes aware that one of the non-lawyer assistants is providing legal advice to clients which is outside the scope of their duties. What should the supervising attorney do to comply with ethical rules on the unauthorized practice of law? A. The attorney should ignore the assistant's behavior unless a formal complaint is filed by a client. B. The attorney should immediately correct the assistant's conduct, inform them of the limitations on their role, and ensure they do not engage in unauthorized legal practice. C. The attorney should report the assistant to the state bar even if the assistant is acting under the attorney's supervision. D. The attorney should inform the assistant's supervisor but take further action as the assistant is not licensed lawyer. Answer. B. The attorney should immediately correct the assistant's conduct, inform them of the limitations on their role, and ensure they do not engage in unauthorized legal practice. Explanation. The unauthorized practice of law occurs when individuals who are not licensed practice law engage in activities reserved for attorneys, such as providing legal advice. Model Rule 5.3 requires attorneys to supervise non-lawyer assistants to it. They do not engage in such unauthorized activities. The supervising attorney is responsible for ensuring that the assistant does not offer legal advice and must take prompt corrective action to prevent such violations. Reporting the assistant to the bar is unnecessary if the issue is addressed internally and the assistant understands the limits of their role. Question 10. During a lengthy legal battle, an attorney begins to feel overwhelmed by the emotional toll the case is taking on them. What should the attorney do to ensure they continue to provide effective and ethical representation to their client? A. The attorney should push through the emotional strain and continue working on the case, ignoring their own well-being. B. The attorney should take a temporary leave of absence to regain their composure and seek support, ensuring that the client's interests are still represented. C. The attorney should delegate all work on the case to junior associate while taking backseat role. D. The attorney should reduce their involvement in the case and let the client handle the proceedings on their own. Answer. B. The attorney should take a temporary leave of absence to regain their composure and seek support, ensuring that the client's interests are still represented. Explanation. Attorneys have an obligation to provide competent and effective representation to their clients. Rule 1.1. However, personal emotional tolls can affect an attorney's ability to function at their best. If an attorney is feeling overwhelmed, it is essential for them to acknowledge this and appropriate steps to care for their well-being. Taking temporary leave of absence allows the attorney to seek support, regain composure, and return to the case with a clear mind. It is important that the attorney ensures the client's interests are still represented during this time, either by a colleague or another qualified attorney. Question 11. While analyzing the root causes of sequential problems in a complex litigation case, an attorney realizes that there is an issue of potential conflict of interest regarding their previous representation of an involved party in a related matter. How should the attorney address this situation to comply with ethical obligations? A. The attorney should continue with the representation as the previous matter was resolved and no active conflict currently exists. B. The attorney should immediately disclose the potential conflict to the client and seek informed consent to continue with the representation. C. The attorney should withdraw from the representation without further consultation, as conflict of interest issues cannot be resolved once identified. D. The attorney should attempt to resolve conflict privately with the opposing party to avoid any complications. Answer. B. The attorney should immediately disclose the potential conflict to the client and seek informed consent to continue with the representation. Explanation. According to Rule 1.7 of the Model Rules of Professional Conduct, an attorney must not represent a client if there is a concurrent conflict of interest which can arise if the representation of one client will be directly adverse to another client, or if there is a significant risk representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, former client, or third person. In this case, the attorney must inform the client of the potential conflict of interest arising from previous representations and seek the client's informed consent before continuing. This ensures that the client is fully aware of the situation and is not prejudiced by the potential conflict. Question 12. When dealing with A complex system that shows occasional breakdowns in communication between various departments. An attorney is asked to evaluate the organization's policies related to confidentiality and privilege. What should the attorney focus on when identifying gaps in the organization's practices? A. The attorney should primarily focus on ensuring that there are no specific policies against disclosure, as the communication breakdowns are likely accidental. B. The attorney should review the organization's procedures to ensure that attorney-client privilege and confidentiality are adequately protected, especially in the event of accidental disclosures or inadvertent communications. C. The attorney should only focus on the communication breakdowns between departments, leaving issues of confidentiality to be handled by the legal team. D. The attorney should disregard minor communication errors, as they are unlikely to impact confidentiality or privilege significantly. Answer. B. The attorney should review the organization's procedures to ensure that attorney-client privilege and confidentiality are adequately protected, especially in the event of accidental disclosures or inadvertent communications. Explanation. Confidentiality and attorney-client privilege are critical aspects of legal ethics. Under Rule 1.6 of the Model Rules, lawyer must maintain the confidentiality of information related to the representation of client. This includes preventing inadvertent disclosures of privileged information. In this case, the attorney should assess the organization's internal policies and identify any gaps where confidential or privileged information could be accidentally disclosed due to communication breakdowns. Steps should be taken to implement safeguards to ensure that such information remains protected, even if there are system failures or human error. Question 13. In a high-stakes environment where multiple challenges to the integrity of the legal process are being presented, an attorney finds that some of the documents submitted by their client may have been altered. What is the attorney's ethical obligation in this situation? A. The attorney should ignore the altered documents if the client insists on using them, as the attorney's duty is to advocate for the client's best interests. B. The attorney should inform the client of the ethical violation and refuse to submit the altered documents to the court, possibly even withdrawing from the case if necessary. C. The attorney should attempt to alter the documents back to their original form before submitting them to the court, ensuring presented in the best light. D. The attorney should submit the altered documents but provide an explanation to the court about the discrepancies in the documents. Answer. B. The attorney should inform the client of the ethical violation and refuse to submit the altered documents to the court, possibly even withdrawing from the case if necessary. Explanation. Model Rule 3.3 explicitly addresses the issue of candor to the tribunal. The attorney has a duty to the court not to submit false evidence or engage in fraudulent conduct. If an attorney discovers that documents have been altered, they are required to inform the client of the ethical violation and ensure that those documents are not submitted. The attorney must avoid participating in any fraudulent conduct and may even be required to withdraw from the case if the client insists on using the altered documents. The attorney's duty to the legal system and the administration of justice outweighs the duty to the client in this instance. Question 14. While investigating a complicated issue between different stakeholders in a legal matter, an attorney learns that a former client of theirs is involved in the case and there may be a potential conflict of interest. What is the first step the attorney should take in addressing this situation? A. The attorney should review the previous representation to determine if there is any direct overlap or substantial relationship between the current case and the former client's matter. B. The attorney should immediately disclose the potential conflict to all parties involved and withdraw from the case if the conflict is confirmed. C. The attorney should continue with the case and resolve the issue if it arises, as the former client's matter was unrelated to the new case. The attorney should hire an independent third party to review the case and determine whether conflict exists. Answer. A. The attorney should review the previous representation to determine if there is any direct overlap or substantial relationship between the current case and the former client's matter. Explanation. In this situation, the attorney must carefully consider whether the previous representation of the former client creates conflict of interest under Rule 1.9, which governs duties to former clients. The attorney must first assess whether the matters are substantially related and if the former client's confidential information would be relevant to the new case. If the conflict exists, the attorney must obtain the informed consent of the former client before proceeding. If consent is not possible, the attorney may need to withdraw. It is crucial for the attorney to evaluate the potential for conflict thoroughly before taking further action. Question 15. During a comprehensive review of a process that needs improvement, an attorney notices a significant gap in the procedures for handling client funds in trust accounts. What steps should the attorney take to address this issue and maintain ethical compliance? A. The attorney should update the procedures and ensure the funds are handled in compliance with the state's bar rules, keeping the client's best interests in mind. B. The attorney should wait until the gap causes problem before taking any corrective measures. C. The attorney should focus only on accounting for the funds and ignore other aspects of trust account management. D. The attorney should disclose the issue to the client but not take any further steps unless the client requests action. Answer A. The attorney should update the procedures and ensure the funds are handled in compliance with the state's bar rules, keeping the client's best interests in mind. Explanation: handling client funds in trust accounts is governed by strict ethical rules, often laid out in the state's professional conduct rules. Under Rule 1.15, attorneys must hold client property, including funds, separate from the attorney's own property and maintain accurate and detailed records. In this situation, the attorney must proactively address the gap in the procedures to ensure that the trust account complies with these ethical obligations and maintains transparency and accuracy. Failing to do so could result in significant ethical violations, potential harm to clients, and disciplinary action. Question 16. In a case where multiple parties have different objectives and the attorney is tasked with negotiating a settlement, what ethical considerations should the attorney take into account when representing a client in negotiations? A. The attorney should solely focus on achieving the best outcome for their client, regardless of how it impacts the other parties involved. B. The attorney should act as a neutral party and try to facilitate an agreement that satisfies all parties, even if it means compromising the client's interests. C. The attorney should work to achieve settlement that balances the needs of the client with fairness to the other parties, but without compromising their objectives. D. The attorney should advise their client to withdraw from negotiations if the other parties refuse to compromise on their terms. Answer C. The attorney should work to achieve a settlement that balances the needs of the client with fairness to the other parties, but without compromising their client's objectives. Explanation: in negotiations, attorneys must act in accordance with Model Rule 2.1, which emphasizes that lawyers should provide independent judgment and advice to clients. While representing clients' interests, attorneys should also be mindful of fairness and the broader principles involved. The attorney should advocate for their client's position but should not engage in tactics that are misleading or unfair to the other parties. Balancing client needs with ethical behavior in negotiations ensures that settlements are fair and consistent with legal and professional standards. Question 17. When working on a time-sensitive case involving complex legal issues, an attorney discovers that they have overlooked a critical procedural step that could negatively impact the case's outcome. What steps should the attorney take to resolve the situation while maintaining their professional and ethical responsibilities? A. The attorney should immediately inform the client about the mistake and try to correct the error as soon as possible. B. The attorney should ignore the oversight if no immediate harm has occurred, as it could be fixed later in the case. C. The attorney should consider withdrawing from the case to avoid being responsible for the procedural mistake. D. The attorney should discuss the oversight with opposing counsel to see if they can agree on a solution without involving the Answer A. The attorney should immediately inform the client about the mistake and try to correct the error as soon as possible. Explanation: under Model Rule 1.4, attorneys have an ethical duty to communicate effectively with their clients, including informing them of any material developments in the case. When an attorney realizes that a procedural mistake has been made, it is critical that they promptly notify the client and take corrective steps. Ignoring the issue or attempting to fix it without transparency could compromise the case and violate ethical obligations. By addressing the mistake and working toward a solution, the attorney demonstrates professionalism and upholds their duty to the client. Question 18. In a case where an attorney is representing a client involved in a highly publicized criminal matter, the attorney notices that a key piece of evidence may have been tampered with. What should the attorney do upon discovering this? A. The attorney should proceed with the case as usual, as the evidence may not be significant to the case's outcome. B. The attorney should report the tampered evidence to the appropriate authorities and take steps to withdraw from the case if necessary. C. The attorney should present the tampered evidence to the court, ensuring that the evidence is not questioned by the opposing party. D. The attorney should destroy the tampered evidence to avoid it being used against the client. Answer: B. The attorney should report the tampered evidence to the appropriate authorities and take steps to withdraw from the case if necessary. Explanation. Under Rule 3.4 of the Model Rules of Professional Conduct, an attorney must not obstruct or interfere with the discovery of evidence, nor can they knowingly use false or tampered evidence. If an attorney learns that a key piece of evidence has been tampered with, their primary duty is to report it to the relevant authorities. Withholding or manipulating such evidence would not only be unethical but could also result in criminal charges against the attorney. The attorney must also consider whether withdrawing from the case is necessary to maintain their professional integrity and avoid any participation in illegal activity. Question 19. While reviewing the legal documents of a long-term client, an attorney realizes that the client's financial situation has changed dramatically and some of the client's previous decisions are now questionable. What should the attorney do in this scenario? A. The attorney should continue to follow the client's wishes without questioning their decisions. B. The attorney should inform the client of the significant changes in their financial situation and discuss whether their previous legal decisions still align with their current needs. C. The attorney should immediately attempt to revise the client's legal documents to better reflect the changes. D. The attorney should advise the client to make drastic changes without discussing the situation further, as it will be better for them. Answer. B. The attorney should inform the client of the significant changes in their financial situation and discuss whether their previous legal decisions still align with their current needs. Explanation. Attorneys have a duty to provide competent representation, Model Rule 1.1, and to communicate with their clients regarding material changes in their circumstances. If a client's financial situation has changed substantially, the attorney review and update the client's legal documents to ensure that the client's current wishes and needs are accurately reflected. The attorney should explain the impact of the changes and discuss potential modifications to the legal strategy or documents. The client should be fully informed and involved in making any decisions about revisions. Question 20. In a scenario where an attorney is representing a client in a family law matter, the attorney discovers that the opposing party is engaged in fraudulent behavior. What action should the attorney take in response to this discovery? A. The attorney should ignore the fraud and proceed with the case, as their primary duty is to advocate for their client's interests. B. The attorney should advise the opposing party to cease the fraudulent behavior but continue with the case as planned. C. The attorney should take reasonable steps to prevent the fraudulent behavior from continuing, including reporting the fraud if necessary. D. The attorney should discuss the fraud with the judge privately to avoid escalating the matter. Answer. C. The attorney should take reasonable steps to prevent the fraudulent behavior from continuing, including reporting the fraud if necessary. Explanation. Attorneys have an ethical obligation to maintain the integrity of the legal process. Under Rule 3.3, attorneys must not engage in or allow fraud in their practice. If an attorney discovers that the opposing party is engaging in fraudulent behavior, they must take appropriate action. This could include reporting the fraud to the court or other authorities, depending on the circumstances. Ignoring the fraud or attempting to conceal it would be unethical and could harm the attorney's reputation and the client's interests. Question 21. While negotiating a settlement on behalf of a client, an attorney learns that their client has provided false information that could impact the settlement outcome. How should the attorney proceed? A. The attorney should immediately withdraw from the settlement negotiations as the client has violated ethical principles. B. The attorney should attempt to revise the false information with the opposing party while continuing with the settlement talks. C. The attorney should inform the opposing party of the false information and attempt to resolve the matter as best as possible. D. The attorney should discuss the situation with the client and encourage them to be truthful. The attorney cannot participate in fraudulent behavior. Answer. D. The attorney should discuss the situation with the client and encourage them to be truthful, as the attorney cannot participate in fraudulent behavior. Explanation. Under Rule 4.1, attorneys are prohibited from knowingly making false statements of fact or law to a third party. If an attorney discovers that their client has provided false information, the attorney must take steps to address the issue and encourage the client to be truthful. Continuing with fraudulent statements could lead to serious legal consequences for both the client and the attorney. The attorney must also consider the possibility of withdrawing from the representation if the client insists on continuing with false information. Question 22. In a situation where an attorney is dealing with an emotionally charged case involving a family dispute, the attorney begins to feel personally attached to the client's cause. How should the attorney handle their emotions to maintain ethical and professional conduct? A. The attorney should allow their emotions to guide their decisions to ensure the best possible outcome for their client. B. The attorney should recognize their emotional attachment and seek guidance from colleague or mentor to maintain objectivity and avoid conflicts of interest. C. The attorney should push through their emotional involvement and continue representing the client without hesitation. D. The attorney should disregard their emotions entirely and adopt a clinical approach, which may not always be effective in sensitive cases. Answer. B. The attorney should recognize their emotional attachment and seek guidance from a colleague or mentor to maintain objectivity and avoid conflicts of interest. Explanation. Lawyers are required to maintain professional objectivity in their representation, even in emotionally charged cases. Model Rule 2.1. If an attorney feels personally involved or attached to a case, it is important for them to recognize these emotions and take steps to manage them. Seeking guidance from a colleague or mentor can provide an external perspective and ensure that the attorney's decisions are based on legal principles rather than personal emotions. Emotional attachment can cloud judgment and affect the attorney's ability to act in the best interest of the client. Question 23. In a case where an attorney is working with a corporate client, the attorney discovers that a key executive has violated ethical rules related to insider trading. What is the attorney's ethical responsibility in this situation? A. The attorney should advise the client to continue with their business dealings and not disclose the insider trading violations. B. The attorney should inform the executive of their ethical obligations and seek guidance on how to resolve the violation without notifying the authorities. C. The attorney should advise the corporate client to report the violation to the relevant authorities and take steps to rectify the situation. D. The attorney should allow the corporate client to handle the matter internally and avoid involvement in the matter. Answer. C. The attorney should advise the corporate client to report the violation to the relevant authorities and take steps to rectify the situation. Explanation. Insider trading is a serious violation of federal securities law, and attorneys are required to comply with both legal and ethical standards in such cases. Under Rule 1.13, an attorney representing an organization must act in the best interest of the organization, which may involve reporting unethical or illegal conduct, even if it involves high-level executives. The attorney should advise the client to take the appropriate legal steps to address the violation and mitigate any potential consequences. Failing to do so could result in legal and professional consequences for both the attorney and client. Question 24. During a deposition in a sensitive matter, an attorney notices that their client is becoming visibly distressed. What should the attorney do in response to this situation? A. The attorney should continue the deposition as planned, as it is crucial to gather information for the case. B. The attorney should request a break to allow the client to regain composure and decide whether the client is comfortable proceeding. C. The attorney should immediately end the deposition if the client is distressed, regardless of the case's needs. D. The attorney should ignore the distress, as emotional reactions should not interfere with legal proceedings. Answer. B. The attorney should request a break to allow the client to regain composure and decide whether the client is comfortable proceeding. Explanation. It is the attorney's responsibility to ensure that their client is mentally and emotionally prepared to proceed with legal proceedings, especially in deposition. While the attorney must zealously represent the client's interests, they must also ensure that the client is not coerced or pressured into continuing if they are emotionally distressed. Taking break allows the attorney to assess whether a client can proceed or if additional support is needed, maintaining both ethical responsibilities and the integrity of the legal process. Question 25. In a situation where an attorney is negotiating a complex contract on behalf of a client, the opposing party's attorney proposes cause that the attorney feels may harm their client's long-term interests. What should the attorney do in this situation? A. The attorney should agree to the clause, as it may help the negotiation process and lead to a faster resolution. B. The attorney should explain the risks of the cause to the client and work to negotiate more favorable terms. C. The attorney should reject the cause outright without further discussion, as it is clearly not in the client's best interest. D. The attorney should avoid discussing the cause with the client and simply accept the terms proposed by the opposing party. Answer. B. The attorney should explain the risks of the cause to the client and work to negotiate more favorable terms. Explanation. An attorney's primary duty is to act in the best interest of their client. In negotiating contracts, attorneys must carefully evaluate all proposed terms to ensure that they do not negatively affect the client's future interests. If cause appears to be detrimental, the attorney should discuss it with the client, providing clear explanation of the potential risks and work to negotiate terms that are more favorable for the client. By providing this guidance, the attorney ensures that the client is fully informed and that the contract serves their best interests. Question 26. When evaluating the legal risks of a new business venture, an attorney discovers that certain aspects of the business model may inadvertently violate federal regulations. What steps should the attorney take to mitigate the legal risks while protecting the interests of the client? A. The attorney should immediately advise the client to abandon the business model to avoid any potential legal issues. B. The attorney should advise the client to proceed with the venture without concern, as any violations are unlikely to result in significant consequences. C. The attorney should discuss the potential legal risks with the client, suggest modifications to the business model to comply with federal regulations, and propose strategies to minimize legal exposure. The attorney should avoid discussing the violations with the client to prevent any unnecessary concerns and allow the business to proceed as planned. Answer. C. The attorney should discuss the potential legal risks with the client, suggest modifications to the business model to comply with federal regulations, and propose strategies to minimize legal exposure. Explanation. An attorney's duty is to provide competent legal advice and help clients understand the potential risks associated with their business ventures. If an attorney discovers that client's business model violates federal regulations, immediately discuss these risks with the client. The attorney should then provide advice on how to modify the business model to bring it into compliance with the law. This ensures that the client can proceed with the venture while minimizing legal exposure and protecting their long-term interests. Ignoring the violations or allowing the client to continue without addressing them could result in legal liabilities for the client and damage to the attorney's professional integrity. Question 27. In a case involving a client facing criminal charges, the client insists on pleading guilty to charges that the attorney believes they can successfully defend against. What is the attorney's ethical obligation in this situation? A. The attorney should respect the client's decision and proceed with the guilty plea as instructed, regardless of their personal opinion on the case. B. The attorney should withdraw from the case if the client insists on pleading guilty to charges the attorney believes are defensible. C. The attorney should strongly advise the client to reconsider pleading guilty, explaining the potential consequences, but ultimately comply with the client's wishes. D. The attorney should encourage the client to lie about the charges to achieve more favorable outcome in court. Answer. C. The attorney should strongly advise the client to reconsider pleading guilty, explaining the potential consequences, but ultimately comply with the client's wishes. Explanation. Under the model rules of professional conduct, attorneys have duty to communicate with clients and provide competent legal advice. Rule 1.4 and 1.1. In criminal cases, an attorney's role is to advocate for their client's best interests while respecting client's decisions. If client insists on pleading guilty to charges, even though the attorney believes they have strong defense, the attorney must advise the client about the risks and consequences of pleading guilty. However, if the client still wishes to proceed with the plea, the attorney must respect the client's decision, as the ultimate choice belongs to the client. This is known as client autonomy, particularly in decisions regarding plea bargains. Question 28. While reviewing a complex litigation matter, an attorney realizes that they lack sufficient expertise in the relevant area of law. What steps should the attorney take to ensure they provide competent representation to the client? A. The attorney should proceed with the case without seeking additional help, trusting that they can handle the matter. B. The attorney should seek guidance from a colleague with more experience in the area of law or refer the case to a more qualified attorney while continuing to monitor the case. C. The attorney should immediately withdraw from the case as they are unable to handle it. D. The attorney should attempt to gain the necessary expertise by reading about the subject and proceeding with the case as quickly as possible. Answer. B. The attorney should seek guidance from a colleague with more experience in the area of law or refer the case to a more qualified attorney while continuing to monitor the case. Explanation. Rule 1.1 of the Model Rules of Professional Conduct requires attorneys to provide competent representation to their clients, which includes having the necessary legal knowledge, skill, and preparation to handle a matter If an attorney realizes their expertise in a certain area, they have an ethical obligation to ensure competent representation. The best course of action is to either consult with a more experienced colleague or refer the case to a qualified attorney who specializes in that area. This ensures that the client receives the best possible legal service while maintaining the attorney's professional integrity. Question 29. In a case where an attorney is defending a client against serious charges, the client asks the attorney to present false testimony to the court. What should the attorney do in response to this request? A. The attorney should comply with the client's request to present false testimony, as their job is to defend the client's interests. B. The attorney should refuse to present false testimony, as it would violate ethical standards, and advise the client about the consequences of such actions. C. The attorney should attempt to persuade the court to disregard any evidence of false testimony, claiming it was misunderstanding. D. The attorney should withdraw from the case. Client insists on presenting false testimony. Answer. B. The attorney should refuse to present false testimony, as it would violate ethical standards, and advise the client about the consequences of such actions. Explanation. Under Rule 3.3 of the Model Rules of Professional Conduct, attorneys are prohibited from offering false evidence or presenting false testimony. If a client asks an attorney to present false testimony, the attorney must refuse to comply with the request, as doing so would not only violate ethical obligations but also undermine the integrity of the legal process. The attorney should explain to the client that such conduct is illegal and unethical and could result in severe legal consequences for both the client and the attorney. If the client insists on dishonest actions, the attorney may have to withdraw the case. Question 30. During a lengthy legal battle, an attorney begins to feel overwhelmed by the emotional toll the case is taking on them. What should the attorney do to ensure they continue to provide effective and ethical representation to their client? A. The attorney should push through the emotional strain and continue working on the case, ignoring their own well-being. B. The attorney should take a temporary leave of absence to regain their composure and seek support, ensuring that the client's interests are still represented. C. The attorney should delegate all work on the case to junior associate while taking backseat role. D. The attorney should reduce their involvement in the case and let the client handle the proceedings on their own. Answer. B. The attorney should take a temporary leave of absence to regain their composure and seek support, ensuring that the client's interests are still represented. Explanation. Attorneys have an obligation to provide competent and effective representation to their clients. Rule 1.1. However, personal emotional tolls can affect an attorney's ability to function at their best. If an attorney is feeling overwhelmed, it is essential for them to acknowledge this and appropriate steps to care for their well-being. Taking temporary leave of absence allows the attorney to seek support, regain composure, and return to the case with clear mind. It is important that the attorney ensures the client's interests are still represented during this time, either by a colleague or another qualified attorney.